started by asking you a question, and I'm interested how many of you actually have a business name. If you've got your own business, how many of you have got a business name? Okay, most of you have got a business name registered. How many of you actually have a website or have thought about creating a website as part of a business that you may want to have in the future? Okay, again, most of you have a website. Pretty easy questions, right? Things that you'd all think about. But how many of you actually have thought about registering a trademark? How many of you have a registered trademark? Okay. See, it always whittles down. So you've got the website, you've got the business, but not everybody actually has a trademark. And what about a registered design? Have you even heard about registered designs before? Okay, so no one here has a registered design, and you're presumably in the fashion industry. Okay, great. So that's very interesting, and that's exactly the sort of answers that I tend to get all around the place when I present. People know a lot of things about how to set up a successful fashion business, but then they don't know how to actually protect it once they've set it up. So I wanted to give you a hypothetical situation just sort of to introduce the issue. What would happen if you got a letter from a designer in Australia or overseas saying, stop your brand, basically stop your selling your items under that brand name because you're infringing on my intellectual property? And it might come on a legal letterhead, and it might basically paralyse your business by saying, I think you're copying me, stop doing that. What would you do? Have you thought about how much it would cost to rebrand your business, to create new swing tags, new websites, the whole thing? It would actually be quite an expensive exercise. And it's not just a theoretical hypothetical, it's actually happened to quite a lot of designers, and a famous one obviously is Tsubi. Now, Tsubi with a K, exactly for that reason. So what happened was, Tsubi was originally Tsubi with a T, and then one day they were going along, they were doing really, really well in the Australian market, as you know, the big success story. And one day they got a letter from a lawyer, the lawyers of an American company called Tsubo with a T, with an O at the end, which was a shoe company, basically saying, we have a registered trademark for Tsubo, you must stop using Tsubi because we're in footwear, you're in clothing, it's very similar, we want you to stop because there'll be customer confusion. So what did Tsubi do? Tsubi basically had to rebrand as Tsubi with a K, and they came to an arrangement. I mean, luckily Tsubo didn't have to take Tsubi to court because that could have really cost a huge amount of money. But what they did was, Tsubo said, okay, well you can stay as Tsubi in Australia, that's your main market, but for any other country around the world, you'll have to be Tsubi with a K. So can you imagine if you were in that position, having to have basically two brands, run one overseas with one label, all the swing tags, the website, everything, and another one here in Australia? And can you imagine how confused your customers would be if that happened to you? So customers who went overseas to the US, for example, might say, well, what's this Tsubi with a K? Is this a rip-off of Tsubi with a T? What's going on? So they decided to phase out Tsubi with a T, and basically they go by Tsubi with a K now, but it was fundamentally because of this trademark problem that they had. And it's been estimated that it's cost them $1 million to do all that rebranding. So it's a significant amount of money. One really interesting one is Colette Dinnigan and Colette Accessories. You might have seen Colette Accessories stores popping up with fairly low-priced, affordable jewellery pieces. And obviously we all know Colette Dinnigan. Well, when Colette Accessories started opening their stores, Colette Dinnigan wasn't very happy. She said, well, you're infringing on my trademark. I'm known as Colette in the fashion industry. I've got a registered trademark. You're infringing on my trademark. And Colette Accessories said, well, you're not known for your jewellery. We do jewellery, but Colette Dinnigan said, well, jewellery and clothes are sort of similar. So basically this is going to court. They've tried to mediate and it hasn't been successful so far. They're going to another court-appointed mediation. Each party has spent a lot of money trying to fight this out because obviously each of them wants to stake their claim. And the interesting thing is, Colette is Colette Deegan's name, and Colette is actually this lady's name as well. So just having your own name as your brand does not mean that you're going to be protected. So even if they come to an arrangement, each party has already spent a huge amount of money trying to stake that claim. So the important thing is really knowing who else might have a similar name registered to yours before you get started, because that might actually prevent this kind of issue happening. The similar one with Morrissey as well, his own name. Morrissey, a long time ago, sold the rights to his brand to Webster Holdings, and when he did that, he sold all the rights to that name. So even though it was his own name, he was not entitled to set up a new label called Morrissey, which would compete with the old Morrissey, which is the same word, isn't it? So it's really quite interesting. And what's happened is actually that's come to a resolution where Peter Morrissey has bought back his old trademark now. So in this particular situation, I think he's done reasonably well, because he sold it for quite a high price back in the day, and now he's rebought it, I think, for a lower price. So it's come about okay. But the point is, he wanted to set up this diffusion line into Big W, and he was prevented from doing that because of this trademark that he'd sold to someone else in the past. So it's really, really important to know that trademarks are brands, and they're very valuable. And just because a trademark is your own name doesn't mean that you can just get away with it if somebody else has it registered. And if we do the flip side, what would happen if you had a great idea and someone else, even at this trade show, saw it and went off and started selling copies in David Jones that were pretty much exactly the same as yours? Is there anything that you could do about that? Do you know what you would do if that happened to you? These things are good to think about now when your business is maybe growing, or maybe you're just starting to think about establishing a business, because once it happens, sometimes it's too late. So you need to think about what you'd have in place beforehand, before you go ahead and go too far down the track. So I'll be talking about IP, which is intellectual property. Now that sounds like quite a complicated concept, and a lot of people say, oh, that's too hard, it's not for me, it's technical, isn't it really, really expensive? And what I want to show you that it's not necessarily, and you should all, because you're all creating intellectual property, you should all be thinking about how you will protect it. But basically you can do three things. The first thing you can do is you can try to stop copycats. Now copycats are rife in this industry, as you all know. Everyone that has a good idea has probably been copied in some way over their career. So the first thing to do is, well, IP will give you some tools to know what to do if you are copied, or to actually prevent those copies from happening in the first place. The second thing, which is really important, as we've seen, is to make sure you're not actually copying someone else. And by copying someone else, it doesn't have to necessarily be blatant copying, but something like the Colette situation. Well, Colette Deegan thinks that Colette Accessories is copying her, and you don't want to be in that position. So it will help you figure out whether you're copying somebody else and make sure that you're not. And the third one is you can actually make money from intellectual property. So once you have some IP rights registered, you can actually license those rights out to other brands, to other companies, to create other things with them. You can also get government grants from a number of organisations like Austrade and Ausindustry. If you have IP registered, you can apply to those organisations and say, hey, I've got this IP registered, I'm a serious contender, I want to do lots of things to promote the Australian economy. Well, can you give me a grant? And there are quite a few grants available for TCF businesses. So there are quite a few positives to having this. And a good example of licensing is Pierre Cardin. We've all heard of Pierre Cardin. Basically, he made an empire not only out of his couture line and his ready-to-wear, but also a huge range of licensed products. Not just perfumes, but he's actually gone so far as to brand food items and cans of sardines and all sorts of things. I mean, he probably went way too far in many of people's opinion, because he sort of diluted his brand name across everything. But he's really proud of that. I read an article recently and he was saying he loves the fact that his name is stamped on all these things. Most importantly, he's made a huge amount of money out of that. It's made him something like the 9th richest person in France. So it's a strategy that you can undertake if you have a successful business to license it out, which basically means renting out your name to somebody else for exploitation. Sean Coombs is a good example from the hip-hop world, who's gone ahead and done, he's got a fashion label, and he's licensed that name onto that label. Okay, so 4 main rights in intellectual property. So first thing I'd want you to know is intellectual property, the words just mean like this broad umbrella term of different rights. And under that big umbrella term come different specific rights that cover different things. So you might have heard the words copyright, trademarks, and a lot of people think they're the same thing, or they relate to very similar issues, and they sometimes use them even interchangeably. I was listening to Robbie Buck the other night on S702, and he was explaining, he was talking about patents but using the words copyright. So, you know, everybody gets it wrong. Basically, think about 4 main rights, and that is copyright, patents, trademarks, and registered designs. Now today I will be focusing on trademarks and registered designs because they're the ones that are most broadly applicable to everybody. But it's important to think about patents and copyright as well. So copyright basically covers copyright covers artistic, creative works, musical works, literary works, and again, that might sound quite technical, but basically, the minute you take a photograph, this film that's being made of me now, that is a copyright work because that's original act of taking a photograph. Writing something, sketching something, a novel, a diary, a blog, a website, the photographs that you've got on your website, they're all things that can be protected by copyright. And the great thing is, this is as long as they're original. So if you've created something yourself, then it's automatically protected by copyright if it falls under those categories and if it's original. And the best thing about it is it's free and you don't actually have to go and register it. So you can start putting the letter C in a circle on your website, for example, on any sketch that you make. Put a C in a circle and the year, and that is can be used potentially as proof of your ownership of that particular copyright. Patents last for 20 years, and you actually have to come up with an invention that's never been done before in the whole world. So it's a very high test. It's got to be new, it's got to be inventive, it's got to be capable of being reproduced and manufactured. And basically, in the fashion world, it might apply to a new type of textile, for example, or a new finish on something that's maybe making it waterproof, etc. Things like that, which are really inventions. They're not sort of creativity and design. They're more the function of the product. So they apply to some designers in some circumstances. For example, a lot of the sportswear companies have patents. Like Speedo, for example, has patents on certain technology that they've created. But for most people in the fashion world, patents would probably be less important. Trademarks is a huge one, and I'll go into that in a second. Basically, a trademark is a brand, so don't get confused about the terminology as well. It's a brand. So you can think about pretty much, we'll look at everybody here. The brand is crucial, it's important. The way that you show your brand, the logo you use, the colours you use, the consistency with which you use it attracts people. So that is something that you want to make sure that you protect. Protection of the appearance of a product. So you can see how important it is for fashion designers. You could protect the appearance of, say, a jacket or a pair of shoes or a bit of jewellery or a watch. The actual physical appearance, not the function, because the function is what patents do, but it's actually the appearance. So we'll go into that in a little bit more detail in a second. So going back to trademarks, we'll focus on trademarks and designs. Trademarks cannot just be words. So obviously words, Sports Girl Portman's, Colette Dinnigan are trademarks, they're words. But they can also be names, slogans, whole sentences can be registered as trademarks. Logos as well, this DL, which is David Lawrence, is a registered trademark. The Chanel C's are a registered trademark. So it doesn't have to be a word, it can be an image as well. And very interestingly, shape, colour they can also be registered as trademarks in some circumstances. So I don't know if you've recently heard the case, the Christian Louboutin with the red soled shoes, hugely famous and popular, thousands of dollars for a pair of shoes. He has put red on the soles of his shoes for many, many years. So he has registered that as a trademark in the United States and saying that everybody who has a red-soled shoe, a customer looking at that person walking past will know that that shoe comes from Christian Louboutin. So recently, YSL, Yves Saint Laurent, created a collection where a couple of their shoes had a red heel and the whole shoe was red. And so Christian Louboutin said, no, we don't like that. We have a monopoly on red-soled shoes. And so they're actually in court at the moment in the US fighting it out because Yves Saint Laurent is saying that trademark should never have been registered. Red should be free for everybody to use. We should be free to paint our soles red. Louboutin is saying, but I've built up this reputation in the red sole of the shoe. It's an exclusive item. Everybody knows that that's me. Even, I don't know if you've heard the Jennifer Lopez song. She's just got a song called Louboutins. And the video, if you watch the video, she's lounging around in these red surroundings. So even she's popular culture reference to those shoes. So it's really interesting to see what will happen with that. But the point is that you can potentially, if you become really well known for a particular colour, an example out of the industry is whiskers for fashion, for cat food, the colour purple. And trademarks last 10 years. So you register a trademark, lasts for 10 years. The great thing about trademarks is you can renew them again and again and again. Have you had an opportunity to renew your trademark yet? You mentioned, yeah. So when the 10 years is up, as long as you're still using it, you can renew that trademark and then you can keep on going, keep on going. You can pass your business on to your kids and they can keep renewing the trademark. So it actually becomes a really, really powerful business tool that grows along with your business. So your business might be quite small at the moment, but in 10, 20, 50 years, it might have really grown and become a huge success. If so, then you want to make sure that that brand is protected, particularly as it's really not that expensive to protect. So how do you actually choose a good trademark? Well, the first thing is you've got to make sure that no one else has already registered that trademark before you. In Australia, particularly if your business is based here. Now, trademarks are registered in particular product categories. So if you register a trademark, your trademark's not going to cover every single product category, from food to fashion to engineering to accounting services, because that's just far too broad. You basically register a trademark for what you do. So if you own a retail store, then you would register your trademark for retail services, for example. If you are a fashion designer yourself, if you are selling clothing, footwear, headgear, you would register in that category as well. So it's a matter of figuring out what do you do, what do you want to be protected for, what's your product category, and then you choose one or more of 45 different classes and protect yourself in that particular class. So the first thing is make sure that the name that you want is not registered already. But how do you know whether it is or not? So the first thing that you need to know is about something called Atmos. So this is a search tool that we've got, IP Australia has on our website, and it's a trademark searching tool. So all you do is you type in the names that you're interested in and click enter, and you'll see whether anything comes up that's the same, or you can put in some variations as well to see if other similar names are already registered. And by the way, the main class, probably for fashion designers, is 25, which is clothing, footwear and headgear. So clothes, shoes and hats all come in the one class, 25. But you might be doing other things, like accessories are in different classes. So I just want to show you, this is what the database looks like. Basically what you do is you just type in a word or two words. So I've typed in Leona Edmiston just to see what she's got registered. And I just hit clicked enter, and then we can see that she's got 5 trademarks registered. So she's got the word, just the plain words Leona Edmiston registered in class 25, and then she's also got some logos as well registered, so for the actual design of the script. So that's where you can see whether anybody's registered what you've got. So the interesting thing is, go home tonight and if you've already got a business, type in your name and see if somebody else has a similar name to you, just so you know. And remember, it doesn't matter if they're registered in a class for maybe engineering or accounting or legal services or something, because if it's completely unrelated, well, it's not going to be a problem, most likely. So it's really, if somebody is making shoes under the same brand name that you want to make clothes, well, that might be considered too similar. Second thing to think about when you're choosing a trademark, if you want to create a new brand, is making sure it's distinctive. So by distinctive, I mean original, new, creative, different. A lot of people get into the, when they're coming up with a brand name, they don't think widely enough. They often think, okay, I'll just call it my own name, which is fine. A lot of people do that in this industry. But the thing is, you can come up with really crazy, creative names, which the more creative, the less likelihood that other people are going to already have it, and the more likelihood that people, when they hear your name, will immediately think of you. So it's a really good, it's a bit of a win-win situation that you can really build a brand around that. Sorry about the quality, but 1 teaspoon for clothing. If you think back, we all know the brand, but if you think back, crazy, 1 teaspoon for clothing, and but now when you hear the words 1 teaspoon, you actually think of this brand. And it really has nothing to do with fashion. It's a really creative name. Another one is Romance Was Born. So instead of calling themselves Luke and Anna, they call themselves Romance Was Born. Again, a really interesting, creative name, which draws attention. And in the age of PR, people blog about things all the time. People are always looking for that big story. If you have a really interesting, creative name, well, that is something that could actually be a story in itself. Where does this name come from? Why have you chosen it? I think a really good one in the fashion world is also D Squared, the Canadian label. D Squared with a 2, it's really quite cute looking and creative and attention grabbing. So think outside the square when you're coming up with your name. So now let's leave trademarks and move on to registered designs. So registered designs, as I said, are basically protecting the appearance of a product. It has to be new and it has to be distinctive. Again, that word distinctive. So basically you have to have been the first and only person in the whole world to have come up with that design. That sounds really hard to prove, but the law, I suppose, in this regard is quite understanding in a way, because it's not like you have to create something so different that it's way out there. You can have a registered design for a dress or for a jacket, as long as that particular combination of designs and elements that you've got in the jacket, so including the pattern, including the shape, the fabric, the length, the additions like the buttons that you might be using, etc. As long as that whole combination has not been created before. And if you legitimately created it, well, it's likely that it hasn't come before. Obviously, people are influenced by things that have come before, but as long as you haven't copied it and have really added a lot of your own personality to something, then you're likely to be okay. So basically, the way you do that is, say you've developed a black and white jacket, black and white striped jacket. What you might do is you might type into the just even to Google black and white striped jacket and see how many come up, and you'll have hundreds, obviously. But as long as you have a look at all of them and say, okay, well, mine's different to that one, to that one, to that one. Maybe mine's longer. Maybe mine has horizontal and vertical stripes. Maybe it has a pink lining. That whole combination will be something that's distinctive to you. So just a few examples. Crocs shoes are registered as a design, and even dresses that we see a lot of the time. But again, this particular combination was registered by Hussey. I think so that it's sort of a silky material, it's scoop neck, long sleeves, this whole combination, and the particular pattern making that has made that dress has made it a distinctive dress. So Hussey's actually really good at protecting their designs. And there have been some really interesting cases in registered design. So one was, we all know Review. review was actually successful against a company called New Cover, for design infringement. So they actually registered their designs, and then they took a company to court, to the federal court. These two companies which ripped off their dress, they took them to court and said, look, your dress is too similar to ours, you've infringed our registered design. And what happened was, they had two different results. So in this particular case, the company Red Berry had quite a similar dress, but it was a different colour, a different pattern, and a different fabric, different print. So it was actually quite different in appearance when the court added up all those different elements, and they said, look, you know what, no, it's not an infringement, it's pretty different. But in the case of New Cover, the dress was actually a different colour. It was like a wrap dress. It was a different colour, it was a different print, but the pattern, the underlying pattern was very similar. It's just a kind of a brown printed wrap dress. And so what happened? Review got $85,000 in damages for that, and it was held yes infringed. So basically, New Cover, the store, had to withdraw all those dresses from sale and pay the $85,000. And the court actually said you would have gotten more damages if you'd actually put on the label, this is a registered design, and put the registered design number, because then that would have warned other brands and consumers that you've actually got a registered design. So that's a really good tip. If you actually have a trademark registered, if you have a registered design, why don't you put it on your swing tags, put it on your labels even, put it on your website, make sure that people know that you've got IP registered and are less likely then to copy you. And it's just logical, isn't it? If someone's looking for someone to copy, would they copy the one that's really thought about protecting their designs and their trademarks, or would they copy a company which has a website and has no reference to IP at all? You'd probably, as a copier, you'd go and copy the company that doesn't really know much about IP. So I thought we'd go into just 3 quick steps of what you should do next. So the first thing is really looking at what is your intellectual property. And for all of you sitting here, it'll be different. Some of you will be very design focused. You'll be creating a lot of new products. Perhaps you're wholesaling, perhaps you're selling to someone else. Some of you might have a retail store. Some of you might design for yourself, etc. So think about all the different things that you might have that might be protected. So for example, we've spoken about something like your website, drawings and sketches that you make, they would be automatically protected by copyright. If you are a couture wedding dress designer, or you make one-off embellished products that take weeks and weeks to make, your one-off item might actually be protected by copyright as well, as sort of an artistic work. Then things like patents as well. So if you make your own patents, or if you have a patent maker who works for you, who makes patents for you from scratch, then those patents actually might be protected by copyright, which a lot of people don't know about. And remember, copyright's automatic, so as long as it's original, then you might actually already have all of this as IP and you don't really realise that you have it. Obviously your name, the name of your business or your logo would be trademarks. So if you're in business, you'll have a name of your business, and that name will be a trademark, so make sure that you consider that as well. And then the garment itself that you are designing. You might be designing 20 garments a range 4 times a year, and that's 80 designs that you make a year. Maybe you design way more than that. So definitely make sure that you do a little math and you kind of figure out, okay, what have I got that's copyright? What have I got that I can get a registered trademark for? Second thing, and we've mentioned this before, is to actually look at what other people have. So what's registered by other people? How do you find out about that? The first thing you should do is do some internet searches. Look up your own name, look up your brand, look up the ATMOS database that I mentioned before, type in your name to see if that name is a trademark. There's another database called ADS, ADDS, which is the design database, which is also on IP Australia's website. In that database, you can actually type in the word, say, dress, or shoes, or jacket, and it'll come up with all the designs that have been registered in that particular category. So that's also a useful tool for you. So you'll see the review dresses, you'll see the hussy dresses, you'll see everything that other people have registered before you. So that's a guide as to what you might be able to register as a design. And just be aware that if you know that other people have IP rights that are similar to yours that have come before, so say someone's got a registered trademark or they've got dresses that they've designed and you're actually copying those, the consequences can be really, really serious. The trademark law has actually recently been amended and there is a particular class of conduct that can be considered a crime now. So if you copy counterfeit brands, etc., you can actually be liable for, well, you can be a criminal. And people have actually gone to jail recently. A 70-year-old man actually went to jail for a short period of time for infringing intellectual property recently, because obviously the conduct has to be really blatant. Like if you're told, stop copying, you keep copying, you keep copying, you keep copying, you become in contempt of court, and then you can go to jail. So that was for selling some fake UGG boots, actually. So it was very interesting. But anyway, realise it can be serious. These companies that protect their brands, they take them very, very seriously, and they often have a lot of money to throw at you to say, hey, we're going to take you to court, and you don't want to be in that position. You don't want to be known as a copycat. You don't want people to write about you saying, hey, this person, this brand is not original. You want to make sure that you're in the industry because you're original, you're creative. And I think that also ties up nicely with the whole sustainability angle, because you want to be around for a long time, presumably, if you're in the fashion industry. You don't want to be a fly-by-night in there just to make a quick buck and sell some crappy, cheap clothes. You actually want to create a name for yourself, to create lovely, beautiful garments that people will wear for years, I assume. So I think it's particularly important to make sure that you're being ethical in all aspects of your business, including not copying other people's property, which is what this is. So the third step then is actually applying. So I've mentioned that for copyright you don't have to apply because it's automatic in Australia. But for trademarks and for designs you actually have to register those, apply for those rights through IP Australia, and then you're granted a certificate and then you actually have that IP registered. So trademarks, you can actually file online. Applications for a trademark online in one class are $120. Then, if the application is actually examined, if the application is accepted, then you pay a $250 registration fee. So that's $120 plus $250 for 10 years. Now, if you go through, this is if you do it yourself online. If you go through a lawyer, you will actually pay much more than that, because they will also do searches for you to make sure that you're not infringing other people, to make sure that the likelihood of getting your trademark through is high. So they give you a broader service. And also, I think if you've got a slightly bigger business where you might not be sure who should own that IP. So for example, a lot of people get it wrong where they send off an employee to register a trademark and then the employee registers it in their own name, for example. Well, this is really important. Make sure that the owner is the right owner, because if your employees registered their trademark in their own name, it's not theirs, it's not their brand, and actually that trademark can be invalidated because it's not the real owner who actually applied for that trademark. And IP is very difficult to fix problems later. It's much better to get it all right at the beginning. And so that's why a lot of people also go to lawyers to make sure that, you know, if they've got a complicated company structure, or if they're in license agreements with other people, that they know who is the right person to actually apply for those rights. So even probably here, there are probably some companies here who are registered or distributors of foreign companies. And sometimes those distributors will file those IP rights themselves, so they'll actually register the trademark in Australia. Now that's an interesting issue because sometimes say the Canadian company might say, please register the IP in Australia, we don't mind. That's fine. But if you register the trademark of a US company in Australia without their consent as your own name, well, that's basically a recipe for disaster, because you're going to ruin your relationship with that company because you don't actually own that IP. You don't own the right to that. And I go to a lot of these trade shows, and sometimes people often really want to do the right thing, but sometimes they don't, and sometimes they actually are quite honest about not wanting to do the right thing. So I've been at a trade show where someone came up to me once and said that he wants to register all these foreign brand names in Australia because he's checked the IP register and he's made sure that they're not registered, and he wants to sell them, he wants to register them here, and then he wants to sell them back to those companies. And there are people that do that, and it's incredibly unethical, and it's illegal because in many cases that those companies will have that better claim to those names. So anyway, make sure that you don't do that. And then the designs, the registered designs, unfortunately you can't file them online, but you can actually get a physical application form from IP Australia, you fill it in and you can submit it, or again you can go through an attorney. Remember, if you're designing clothing, shoes, hats, then that will be class 25. If you're a retailer, I think that's 41, but don't quote me. Other items like accessories are complicated because depending on if it's a wooden bracelet, for example, that you sell, or if it's silver and gold, it's in different classes. So just make sure there's actually a really easy way to search on our website. It's just a class search, so you can just type in shoes and it'll come up with whichever class is appropriate. So it's actually maybe much simpler than I'm making it sound, but I hope I'm making it not sound too hard. So then once you've registered your IP, is that the end of the story? Well, no, because once you've got it, you need to actually use it, and you need to show people that you've got it, like we've said. So the first thing is, and this is maybe a silly point, but you've got to keep track of it. Say you've registered 20 designs, you've got 3 trademarks, then you go and have a patent and you've got all this copyright. Who's taking care of that? Where is it? Is it just sort of one employee, your admin person who's filing it? Where are they filing it? Are you doing it yourself? And I really suggest have a folder that you just stick IP on the folder, and then you put anything to do with IP Australia, any letters you get, any threatening letters from other lawyers you might get, put all of it in the one place. So it's really, really easy. If you get that threatening letter from a lawyer, you can actually open up your folder and go, hey, I filed my IP right, 20 years ago, and why are you writing to me now? I can prove that. I've done it 20 years ago. So, and also, you've mentioned you've got a trademark registered. Well, do you know when it's up for renewal? Make sure that you know, say it's up for renewal in 2015, and it might sound silly, but put a calendar entry or put something to make sure that you remember to renew it, because if you don't renew it, well then it lapses. So it's really important to be aware of that. IP notices is what I've mentioned, like the C in a circle for copyright. Around sometimes on brand names, that basically means a brand name is registered as a trademark. So once you register a trademark, you've got a trademark, so you can actually go ahead and put that R in a circle on your trademark because it's registered. The TM, you might have seen as well, the letters TM, a lot of people don't know what the difference is. The TM you can all use from today on your brand name, because it just basically shows that you are intending to use something as a trademark. So even, say you want to file it next week, from today you can already put TM on there to make sure that people know that you want to use that as a trademark. I think I was almost at the end. Another important thing to note is overseas. Unfortunately, if you file a trademark or a design in Australia, it's only applicable to Australia, so it only covers you in Australia, which means that if you want to protect your brand in the US, in China, in Singapore, you will have to go and file applications in those countries. Now, lawyers in Australia can do that for you, so you can actually go to a lawyer and say, hey, I want these 3 countries, can you file an application for me, which is fine. Or you can actually go through IP Australia. There's something called a Madrid protocol, and if you go up on IP Australia's website you can read about it. It allows you to really quickly register a trademark in multiple countries. So you get a form and it's basically got a list of countries, and you just tick the boxes that you want to register in. Off it goes, and basically it's still examined by all the different countries, so it might take a little while to get all those back, but it's an easy way to structure it. Let me just remember what else there was. Any questions while we're waiting? So, if you register a trademark in one country, or if you apply for a trademark in one country, you've got 6 months in which to register it in other countries, and you get the benefit of that first filing date. So say if you registered your trademark on the 1st of January this year in the US, and then before June you decided, okay, I want to register it in Australia as well, you could apply, and basically it's called a convention application, mention that American application that you've got, and your Australian application will be backdated to that American date. So it's actually basically, in a nutshell, it gives you an extra 6 months. And in IP, it's very, very important, like every day matters. So the earlier that you register something, the better, because obviously then you can prove that you were first. Now, if you've missed that 6 months, it doesn't mean that you can't register it. You can certainly register it still in Australia, and it's the same sort of process. You can go on IP Australia's website, you pay the fee, you've got the benefit of already a list of all the products and the classes that you want, and the name, so it's basically just doing the same thing here in Australia. So unfortunately, you do have to do it in all the countries. So I'm not suggesting that you should register your IP in every single country around the world. It's a matter of what your main target markets are. So if your main markets are Australia and the US, well, make sure that you register in those 2 markets. If you're thinking, okay, maybe I'm really hoping in 2-3 years to be in Japan, well, that's what you might do too. You might register your trademark in Japan now, just to prepare for that move into Japan. But if you have no interest in say, filing application, or being in Europe, then don't worry about filing them in Europe. Make sure that you're registered in your main markets. Firstly, go on IP Australia's website. It's in your little booklet, ipaustralia.gov.au. There's lots of information about trademarks and designs and patents and everything that I've talked about. Second thing, if you want a free consultation with an attorney to discuss what IP you've got, what IP you might need to register, how do you actually go about registering a registered design, all of a bit more detail to your particular circumstances, there's an organisation called IPTA, IPTA, and I think their website's just www.ipta.com.au. It's the Institute of Patent and Trademark Attorneys, and they basically are an institute that's made up of lots of different firms, law firms and attorney firms, and all you have to do is phone them up. They're actually based in Melbourne, so you phone them up, the phone number's on their website, and you say, hey, I've heard you do a free half-hour consultation, can I please have one? And then they'll say, well, what rights are you sort of focused on? Do you want a consultation on trademarks or on designs or on patents? And you might be specific and you might say, oh, I'm only interested in designs. Or you might say, oh, I'd like to know a little bit about everything. And book it in. They'll book it in for you. It's free. You don't ever have to see that lawyer again. It's obviously confidential. And the best thing that I can advise you, 20 minutes, half an hour goes really, really fast. So when you go and see that lawyer, bring everything you've done with you. You know, do some of those searches that I've said before, and bring the results to that lawyer and say, hey, this is what I do, this is my brand, this is what I've seen that others do. Do you think I'm too similar? Do you think I should be taking action against that person? What do you think should happen? So that's, I think, a very big tip. And the second thing to think, don't think that if you have IP registered and if you don't have $500,000 to take someone to court, that it's of no use. Basically, it's in this industry, if you find out that you're copied, sometimes it's really enough to get a lawyer or to draft a letter, and it's called a letter of demand, or other terms as well, but someone to draft that letter of demand to basically say, my client owns the rights to this, here's the number, please stop using this, you've got 30 days to stop, this kind of thing. In many, many cases, that person will get scared and will stop. So that's important, but you'd be really surprised in how many people just want to make a quick buck. If they're threatened with legal proceedings, they're just not going to go ahead with it. So make sure that you can do that. You can write blogs, you can forward get the PR going as well about the fact that you are the righteous party. If you've really got the IP rights, then you're protected. You know where you stand. You know you've got those rights. So you don't always have to end up going to court. And there's an overlap where if your products overlap, they really should be registered as designs, and it's mostly if they're actually mass-produced. So if you start mass-producing, and sometimes they use the number 50, if you're creating more than 50 of that item, then you really should register them as a design. It's safer to do that. Copyright, particularly there have been cases actually, the Polo, Ralph Lauren case about embroidery, and it was held, I think, that it didn't apply copyright, so they should have actually registered it as a design. So it's pretty complicated. The minute you start taking two-dimensional things and making them three-dimensional, it's a very grey area of the law, and that is definitely something worth talking to the lawyers about when you mention to them.